Hello everyone and welcome back to the channel. This is SNIGDHA MOHAPATRA, intern at LEXCLIQ, and in today's video I will be talking about position and powers of director. A director is not a servant or any master. They are rather the officers of the company. Director is in fact a director or controller of a company and he manages all the affairs of the company. However, a director can work as an employee in a different capacity. That there are times described as agents, as trustees, and sometimes as managing partners. Now, what are the different positions of a director in a company? First, directors as agents. In the eyes of law, directors are termed as the agents of the company. It was recognized in the famous case of Ferguson versus Wilson, 1886. In this case, Ferguson, the plaintiff, had an option to subscribe for some shares of the company and therefore he applied for them. The directors of the company allotted the whole of the shares that are authorized capital to other people, including themselves. Later on, the option which was given to Ferguson was of no worth, and he sued Wilson, who was one of the company's directors, to transfer some of his shares to him and pay damages. However, the claim of F failed because the directors were only acting as agents of the company and are not responsible for personal liability. However, the directors are not completely like agents, as agents are appointed but directors are elected. Directors are more like managing partners. The court said that the company is not a person, it acts through directors, and in regards to this, it is the case of principal and agent. Directors are the agents of the company and he conducts the business. They act on behalf of the company and he makes the company liable, not himself. In other words, directors cannot be held personally liable for any default of the company. The responsibility of an agent compels the directors to conduct the business of the company in the same way as agents do. They should handle the work with care, skill, and diligence. They are accountable for all the assets of the company that is under their control and the profits from the company's assets. Directors cannot deal with the company's affairs on their own and they are required to disclose the personal interest if they have any in the transactions of the company. Directors represent the shareholders to conduct the business of the company on their behalf. Directors may perform roles in a company like allotment of shares, raising of loans, and investment of funds in the company. But directors cannot bind other shareholder unlike partners. They are elected and can also retire. Next comes directors as trustees. Directors are also described as trustees of the company. They must account for all the money over which they have control. Directors must act and deal with the benefit of the company. They should deal, they should exercise with honesty and it should be in the interest of the company as they occupy a fiduciary position. They are the trustees of money and property of the company that are under their control and the powers that are entrusted to them. Directors are the trustees of the company and not in individual shareholders. This principle came in the case of Percival versus Wright. In this case, the directors purchased the shares of the company, but before this company's sale was undergoing without disclosing this. The plaintiff claimed that this non-disclosure was a breach of contract and fiduciary trust. It was held by the court that no fiduciary duty exists, hence the directors were not bound to disclose. A trustee is the owner of the property and deals with it as his principal. Now, what are the directors as organs? The board of directors are also recognized as the primary organ of the company. Now, what is the personal liability of these organs? According to the Companies Act 2013, a director is liable for any loss, damages, or costs suffered by the company, either direct or indirect consequence. He or she will be liable if they breach certain provisions of the company. Now, what are the different powers of directors? The powers of the directors are coextensive with those of the company mentioned in the memorandum and articles of the company. Make calls on shareholders, authorize the buyback of securities and shares, issue security and shares, borrow monies, investing the funds, grant loans, approve the financial statement, approve the amalgamation or merger, diversify the business, and take over a company are a few powers the directors hold. However, there are two important restrictions on the powers of directors. When the board is not competent to do what the Act, memorandum, and articles require, that is done by the shareholders in general meeting. And secondly, the directors are required to act according to the memorandum of association and the articles of association and other regulations such as the Companies Act that are consistent with the general meeting and act with good faith in the best interests of the company. Thank you so much for watching the video and see you in another video.